You know, every document, even the most boring-looking legal papers, they actually tell a story. And today, that's exactly what we're going to do. We're going to decode one of these documents to find the human story hidden inside all that jargon. Ready? Let's get into it.
All right, so take a look at this. I mean, it's just a wall of text, right? Full of all these fancy legal phrases. It's pretty intimidating at first glance. It could be about literally anything. But this isn't just a random page of words. No, this is the final chapter of a real-life story, a real dispute, and our job is to figure out what that story actually is.
Okay, first things first. Every story needs a setting, and ours is right here, the Office of Administrative Hearings in Phoenix, Arizona. Now, you might be thinking courtroom, but hold on. This isn't your typical scene with a judge and jury. An administrative hearing is, well, it's a totally different kind of place. It's where they handle specific disputes, often with government agencies, or about very specific rules, like housing regulations. So we know right away our story is happening in a very particular, very formal place.
And of course, what's a story without characters? In this corner, we've got Jack L. Burns, and in the other corner, the Hunter Creek Ranch Homeowners Association. I mean, come on, that's a classic setup, isn't it? An individual person versus their HOA. I bet a lot of you can relate to that kind of tension. We don't know the juicy details of what they were fighting about, but we've got our two sides clearly lined up.
So, let's get their roles straight. The document calls Mr. Burns the petitioner. It sounds complicated, but it's really not. It's just a fancy way of saying he's the one who started this whole thing. He filed the complaint. And that makes the HOA the respondent. Pretty straightforward, right? They're the ones responding to his petition. So just to be clear, Mr. Burns kicked this off and the HOA is the one on the other side.
Okay, let's get to the plot. What actually happened? If you dig through all that text, you'll find this really important phrase. The petition is dismissed and this matter is vacated. So what does that mean in plain English? It means the case is over, done, finished. But that's just the what. It doesn't tell us the how or the why. A case can end for a lot of different reasons. So what's the deal with this one?
Well, the clue is hiding in plain sight, right at the top of the page. It's that word, stipulation. What on earth is a stipulation? It's basically a formal agreement between the people in the lawsuit. And that tells us something huge. It means a judge didn't bang a gavel and pick a winner. Nope. What happened was Mr. Burns and the HOA actually talked to each other, and they decided on their own to end this thing. They just agreed to stop fighting.
But hang on, because here comes the real kicker. This is probably the most important phrase in the whole document, and honestly, most people have no idea what it means. It says the case is being dismissed with prejudice. Those two little words, with prejudice, they change everything. So what does that actually mean?
Okay, here's the deal. It's a tale of two phrases. If a case is dismissed without prejudice, think of it like hitting the pause button. The person who started it can just unpause it later. They can file the exact same case all over again. But when it's dismissed with prejudice, that is a full, permanent, irreversible stop. The case is over for good. It can never be filed again. It's like the door has been slammed shut, locked, and the key thrown away.
And that right there, that's the ending to our story. By agreeing to dismiss this thing with prejudice, both Mr. Burns and his homeowners association are basically shaking hands and saying, this is over, for good. Whatever the problem was, it doesn't matter anymore. This agreement is the final word.
So how quickly did this all happen? The document gives us a little timeline. Check this out. The agreement, the stipulation, was received on January 20th, 2009. And then, just 3 days later, bam, January 23rd, the judge signs the final order. That's it. It tells you that once the two sides decided to end it, the official legal part happens super fast.
And that judge's signature? That's the last piece of the puzzle. See, Mr. Burns and the HOA made the agreement, but it's the signature from Judge Louis D. Kowal that makes it all official. It's what turns their private deal into a legally binding court order. Think of it as the final stamp of approval from the legal system saying, yep, we see this and it's final. And hey, just in case anyone was still confused, the document literally spells it out for us at the very end. It says, this order is the final administrative decision. You can't get much clearer than that. The system is basically shouting, there are no more steps, no do-overs, this is the end of the line, folks.
So let's put it all together. Let's recap the whole story we just uncovered. Step 1, a problem pops up between Mr. Burns and his HOA. Step 2, Mr. Burns files a formal case. But then, Step 3, instead of this big, ugly fight, they talk. They actually reach an agreement. Step 4, they make it official by filing that stipulation to dismiss with prejudice. And finally, Step 5, a judge puts their signature on it, and just like that, their resolution is official and permanent.
And really, that's what this is all about. This document, which looked like a bunch of impossible-to-read jargon when we started, isn't really about legal technicalities. It's the last chapter of a human story. Yeah, it's a story that started with a conflict, but the most important part is that it ends with a resolution. Two opposing sides found a way to agree and move on, permanently.
Kind of makes you think, doesn't it? We always imagine the dramatic courtroom battles you see on TV, but this shows us a different path. How many conflicts in life, big and small, don't end with a big explosion, but with a quiet, final agreement to just be done with it? It's an interesting thought. Anyway, thanks for digging into this with me.